Appeals, Division 1 is now in session.
You may be seated. Good morning, Council. We are here now for oral argument in CV21-0728, Woyton versus Ward. As I think you both know, we record and live stream our proceedings, so please give your name and the name of your client when we begin. You have a maximum of 20 minutes per side. You are not required to use all of that time, but you are welcome to do so, and you are welcome to reserve some for rebuttal, but as you know, you need to keep your own time for that. Keep in mind, we have read the briefing, we have studied the record. Some of us are a little more familiar with it than others, but we are all familiar, and we discussed the case in conference this morning. So we're ready to go when you are.
May it please the court, Keith Berkshire for the appellant, Lucas Woyton. I assume Judge Perkins is more familiar with it since you wrote the last opinion. It's nice to actually be back at the actual podium and not at one of these tables, by the way. This case would appear, I guess, that it's a factual case about findings and weighing evidence. But the reality of this is this enough to do a relocation? And the reality here is that if the very sparse findings in favor of a relocation are enough, essentially any parent in a rural city in Arizona will always lose. Okay? The findings are there's more job opportunities in Boston than Yuma. Well, I think we'd concede that. There's more potentially better schools in Boston than Yuma. And that's basically what the findings here were. That shouldn't be enough to allow a relocation, especially when one of the parents...
What is the burden, though? Isn't it preponderance of the evidence? Aren't you kind of asking us to change that burden?
Well, I think that, again, we're not saying this is some clear and convincing evidence burden. That's not in the statute. There's not a lot of case law on that. But it also has to be weighed just in looking at what the legislature has done over the years in the relocation statute. As this court analyzed in the first case, in Woyton 1, Arizona has gone repeatedly to make this more difficult to relocate. It's always been, as this court said in Gutierrez, it's even a crime to take the kids out of state if you do it without permission, as was done in Gutierrez. So I think that it has to be more than, hey, this school on School Digger ranked, 0.1% better than the one where you're relocating from. It has to have some sort of stronger burden than just that 1 inch on the scale, because if that's all it is, if you have two fit parents and somebody wants to move to a bigger city where their family is, that's what this case was. You moved near your family to a bigger city, and implicitly, a lot of Arizona counties would always lose. If you're in La Paz or something else that has limited job opportunities and their family lives in Vegas or San Diego or even just Phoenix, then if that's all the difference it is, if that's all it takes, then you'd have all these outlying counties that would always lose to the major cities because they're always going to have those better opportunities. And
let me understand a little bit better your argument. Is your argument that, so the Superior Court here went through in some detail each of the factors that they're required to go through. Is your argument that the court did not sufficiently explain the sort of the link between the findings under those factors and the determination of best interest on relocation? Or
it is. Well, sorry, please finish.
I guess it seems like you're also maybe making an argument that as a matter of law, certain factors can't standing alone provide a basis.
I think that we have to look, and again, not to explain to you what Woyton 1 was, but Woyton 1 at least went through and said, hey, there is a burden against this, that you have to do all these factors to examine them. And we quote Owen v. Blackhawk in a MEM decision in Ramos and Heard that talk about, the Court of Appeals actually has to look at why this was done, not just this factor was in that favor, but how the overall benefited the best interest and how they weighted it, that was what tipped the scale. Here we have, again, very minimal. There's family in Boston, well, some extended family, which then there was clear errors in the factual findings. Not that I normally ever bring this up, but like my client's other child, saying they're 100 and something miles away when they're 50 miles away. That's a complete error, which should be examined, because if they're within a hour car ride to see the kid's stepbrother, then that is definitely a relevant factor versus grandparents living nearby. But it is, Judge Perkins, I mean, what we're basically saying is they didn't say how that they got to, from those factors, how it's the best interest to relocate. It's, okay, the schools are a little better, totally misquoting an email, by the way, which we put in our record. But that there's some family nearby and those things. They didn't show how that totally tipped the scale and weighted that those things are so important versus the fact that they lived in Yuma versus the fact that they were both, the father's employed in Yuma and they moved there voluntarily and those types of things. But again, I think it has to come back to the reason we included the legislative history and so forth, which was, gone through again in Woyton 1, which is to show that Arizona, the legislature clearly had an interest in it shouldn't be easy to relocate. And so these factors, just if it came down to just a preponderance, then if all it was a preponderance that one factor slightly weighed more without a more substantial burden against it, then all it would take is a better school in Phoenix than Yuma, no other factors, and you're going to win.
But and this goes back to the earlier question, is someone who grew up in Apache County, attended St. John's High School, very sympathetic to your argument. I think as a matter of policy, that's what it should be. But I don't read the statute as saying that there's a higher burden than just preponderance of the evidence. And in times that could be down to 50.01. And we have to let trial courts at some point decide that, unless you can point me to something textually that says that it's...
Well, and I think that goes... Sorry to interrupt you.
No.
I think that goes back to, even just more generic law statements, the 25-103 stuff, the 25-403-02, about this, having both parents substantially involved in the right to this, the generic parental rights under, the Parents' Bill of Rights, these things, to be involved, that if that's all it took to remove them from you was this 50.01, that I don't think that's the intent of the legislature in any of this, especially when you look at the other case law about how important parents' rights are. So while I agree that...
What is your textual hook, though? What can I point to and cite to in the statutes that says it's got to be more than just the normal preponderance?
Well, I think, again, under 103 and 403-02, the right to be substantially involved in those things, that a relocation does absolutely take that away. I mean, this court's case law in Woyton 1 and in Barron and things like that have repeatedly been cited about the level of involvement and the rights of both parents in that. That, again, this isn't a... Parents almost have more rights across town to get equal parenting time than to prevent a relocation. And that's that's kind of axiomatic, that it's almost harder to prevent a relocation than just it is to get equal parenting time if you're in town, and prevent something that goes this far. Again, there's not cases, really cases directly on point on this. I mean, Woyton 1 was the first one that said you actually had to make written findings. But if you look at Owen v. Blackhawk and cases like that talk about how detrimental it is to do these things. And again, I know Gutierrez wasn't really just a relocation case, but it can't be ignored of what was said in there of how serious this court took moving out of state. I mean, it's a crime to move out of state, which is what occurred here, and the court didn't weigh that against mom at all. When she moved out of state, I mean, the court repeatedly found she moved without permission, which under Gutierrez says is a crime of custodial interference. But if you read these, again, the generic cases just about the right to parent, by saying it's 50.01, that one thing that, you have everything is equal, that grandma lives that close, that's enough to allow relocation across the country at such a significant distance. That can't be how the intent of the legislature was read when they do all these statutes, 408, 103, 403-02, in unison. You have to look at the entire context, that the idea was to keep parents together, to keep them with maximizing parenting time. And so if a relocation is that easy, it defeats the point of all those statutes.
Let me ask you, let's assume that we agree that the Superior Court did not sufficiently explain the why.
Yeah.
Gave the factors and the review of the factors, but didn't sufficiently explain the why. We could reverse and remand for more factor evaluation. We could stay the appeal and send it back for the court to redo its order and sufficiently explain it so that there's a more clear basis for the appeal. I guess, what is it that you think would be the right remedy here, given it's been another 14 months or so from the time of the hearing? That is the nature of this litigation. At some point, there needs to be some finality for the child and for the family.
Well, that's side note of why I think special actions on these issues should be granted, because you don't end up 3 years down the road. But no, I mean, to your question, Judge Perkins, I think that where are the burdens on these things? Like, again, my opinion, looking at the legislative history and when you combine all the statutes, I think the burdens on these relocations need to be the stronger burdens like are done in non-parent cases that the court has examined, and that while it's only a finding of best interest under 24-409 for non-parent, this is a stronger burden given the impact to the child, given the impact of allowing a relocation. It really has to be a more stringent burden than just the 50.01. And I think that the non-parent cases, because of the impact to the parent, which is the same impact here, can be looked at.
Does the statute in non-parent cases also have the significant detriment link?
Well, that does under 49A for custody. But
the legislature has told us in those cases.
But that was just to get custody. That's under 49A, not 49C, which is the presumption for just visitation under non-parent. But I'd agree. I mean, the legislature has gone farther on this. But again, I think that you can't ignore they have the burden of, the legislature did dictate they have a burden of proving it. They didn't say by clear and convincing evidence or strong, whatever. But the rest of the case law on custody about the impact on this, about kids and the parental rights here, I think can't be ignored just in the purely contextual analysis of one section of 408, that it's just the burden. Because it's so impactful.
I think Judge Perkins was trying to guide you a little bit. So, again, assuming that we're not prepared necessarily to second guess the finding of the trial court, and there's a procedural, but we've all identified that there's a procedural issue and they didn't explain why, or the trial court didn't sufficiently explain why the findings it made actually led to the result that it imposed. What is our remedy? How do we fix that?
I do think that, again, like some of the cases we cite, even in Owen and Ramos, the MEM decision, they talk about that you need to explain more. I mean, that's always the default of, it seems like this court on any of the custody things is like, please tell us how you got there.
But sorry to interrupt. Is that just on the existing record? I mean, or are you counsel going to be fighting and saying, wait a second, 14 months have gone by.
I know,
there's a lot of things that have happened. We need more evidence.
Well, and that's frankly the problem with litigating these cases, Judge Brown, is that this is the court has to take into account the new. I've got another one of these that we won on appeal that I'm going back to trial with, a Division II case that I'm going to trial with in another month, and it's the same exact issue. We got asked by the trial court, well, what am I supposed to look at? Can you ignore, what if one of the parents after the fact got a DUI and is a crackhead now? Like, can you ignore that to look at the relocation? I mean, I think there has to be some, I think there has to be some examination of both, but the old record really at the time of the relocation should be the predominant concern, especially in a case like this where you had
Could we stay the proceeding and remand to the trial court just for an explanation?
Obviously, our preference is...
I assume you would concede the court made detailed findings on all the factors.
I agree that they did make findings on all the factors as required under Woyton 1.
Really what we're missing is a sentence or two possibly even that says, and because factors 1 through 7 are neutral, factor 8 cuts slightly in favor of the father, factor 9 cuts slightly, and I'm making up the numbers. The mother, I have balanced those and weighed those and find that this is in the child's best interest. Isn't that what we're missing?
I mean, I think it frankly needs to be more than a cursory sentence that I've balanced these, because, I mean, that doesn't actually show how they balanced them, why they thought. I mean, the analysis of why this is more important, one is more than important the other, I think needs to be a little more detailed than that with something that's significant. Like, I find that the grandparents' involvement is very important to the kid versus, father's involvement or something to that. I mean, something to that effect. Again, but I think our main request out of this is really that based on the legislature, based on the other cases, it can't be just that simple, that it's just that minor preponderance. This should be a more strict burden on that, just based on the other cases that talk about relocations, that talk about generic parenting time, and that talk about parents' fundamental rights.
Can you point me to, in the record below, and I hate to put you on the spot, I know this is horrible, I hated that when I would get assistantly here, where you urged the trial court to say that there was a higher burden than preponderance of the evidence?
Well, we did go through and quote in our pretrial about the things about Woyton and the legislative history of how we got there.
But did you ever affirmatively say, this cannot be just a preponderance of the evidence, it needs to be something more?
I didn't do the trial. I don't know. If I don't remember that in there. Frankly.
I knew it was an unfair question, but
no. And I to be honest, I don't think there was we have it higher, and typically we do it from the pretrial standpoint, so we have it in writing. But we did go through the analysis of why the prior case law and these things about why this can't be that simple, and we did analyze those things, and we obviously analyzed them in Woyton 1. But again, I think it's like the education component here. It's tough to go from a policy standpoint. I mean, some counties, cities would always have this disadvantage. And again, there's no way that being a very rural state like we are, or we have a lot of populace in rural counties and so forth. I've represented a lot of people up in Kingman, and we'll be litigating about schools, and my client will live 70 miles outside of town. Well, obviously the 20-person school that's there is going to have a disadvantage to something else. But I can't imagine anybody would think that the legislature ever intended that factor could be enough to allow a parent to essentially, for all intents and purposes here, lose their children for a substantial period of time, especially when this kid becomes school age. You're really limited. This isn't Phoenix and San Diego where you see them every weekend. This is Phoenix and Yuma and Boston. This is about as far away as you could get, given my client having to fly out of some other big city. So again, we think there is the issue with having enough analysis of why these things weighed in mom's favor, but we also think what we're asking also is that the court come up with essentially a statement about the difficult burden that is relocation, which does line up with prior case law that this court did, and it even lines up with Woyton 1, but it definitely lines up with Gutierrez, Hayes, Parents' Bill of Rights under 25601 and 1601 and 1602, and so forth. I'll reserve the rest of my time.
Good morning. I'm Charles Van Cott, and I represent the appellee Tiziani Ward. The first line in Mr. Woyton's brief says that relocation should be difficult, and I would submit in this case it has been difficult. It's entailed 2 trials, at each of which the trial court concluded in favor of relocating the child to Boston, that the relocation was in the child's best interests. The first time around, the trial court did not look at 25408, apart from in a post-trial ruling where he actually analyzed the factors after the fact, and it got reversed and sent back and remanded with instructions to follow the statutory factors. The second time around, that's what the trial court did, and as you said, made extremely detailed findings as to all of the factors. And at one point, he sort of suggested the case hinges on education. He also wrote that it's dependent on the current situation rather than the situation at the time of the decree, the time of the first trial. And I would submit that Commissioner Green looked at she spent a lot of time focusing on the circumstances around the departure from Yuma and everything in between in the current situation too. She looked at all of it. And what she did in the end is after doing that, she said, well, first of all, what makes this difficult is that the proponent of relocation has the burden of proof. That's where the difficulty lies per the statute. And so My client had that burden, and she surmounted it. And in the end, the trial court sort of said, well, I've looked at all of these factors, and based on all of that, I find that the relocation to Boston is in the child's best interest. She also wrote correctly, and there's a case called Pollock that stands for this, that she didn't consider or emphasize any particular factor. Instead, she weighed them all collectively.
So counsel, hypothetically, let's say, because many of the factors here were, I would label as neutral, not favoring either party necessarily, or the court didn't, the court specifically said neither party was favored. What if every factor said neutral, same, all the way down? So everyone goes to their chambers and flips a coin?
Well, no, in that instance, if it's a preponderance of the evidence standard,
the court can just say, I find it in the best interest, one sentence, after considering the factors, I rule in favor of the petitioner.
Well, no,
does that pass muster?
In that hypothetical, I'm not sure that would be the right answer, if it's a preponderance of the evidence test, but we don't have that situation
Why wouldn't
here.
it be, though? The court's weighing
Well,
the
if the
factors.
preponderance of the evidence is 50-50 or 50.01, I'm not sure what the answer is to your hypothetical. But in this case, the factors aren't all neutral, and it's not just education.
What else is it?
Well, you read about the circumstances surrounding the departure, and I do want to say, because it's been written several times, my client did not abscond from Arizona. There was an argument and then an incident in early May. In fact, when that happened, she'd already packed up the entire house because they were both moving. And after that, she moved into a domestic violence shelter in Yuma, where she stayed for a month. And so one of the elements, now the court found, both parties acted in good faith. And I would also say that, you can sort of re-examine those sorts of things too, because that's actually true in her case. She did act in good faith, but she didn't run to Boston.
Counsel, the trial court order that you're defending here says it is undisputed that when mother originally left Arizona for Massachusetts, she did not give advance notice to father, and she did not have father's permission to remove the child from Arizona.
That's true. It also says, though, that the move was congruent with plans that the two of them had been discussing and shaping, and that in fact she went to Boston in accordance with what they both were planning to do almost immediately after she left. Also, they were continuing to communicate about those plans even after. Sorry.
If you could draw your remarks back to what Judge Brown was asking, though. I think we're getting a little far afield in debating them. If you could point us in this decision to which factors, other than the educational opportunities and the availability of the grandparents, that the court explicitly or very clearly in some fashion identified as non-neutral.
Well, I think I would sort of read the entire discussion about what was happening at the time of the departure. And she talks about both clients' behavior, but I don't think that's a neutral analysis, not from my perspective. I think she was justified
So how
in
would
making the
we
move.
say it counseled in one favor or the other?
It would favor Ms. Ward. Also, the judge went through 600 pages of medical records. And again, in terms of accusations that my client was abusing narcotic medication, and that was, just her instability, mental instability, she went through all of those things. And again, to my point, if you read those records, a recurring theme dating way back from before the departure and continuing all the way through them is that she sought treatment for being the victim of domestic abuse. And I think that at least demonstrates that she acted in good faith when she moved. She certainly felt that, and it's not just that she testified to that. Her actions.
I'm sorry, I'm missing the link between allegations. I don't think there was any domestic abuse finding, was there?
The issue is good faith.
Okay, so I'm not following why good faith flows from allegations of domestic abuse that were not sustained.
I would say the evidence sustained them. And again, in reviewing this.
Again, okay, let's assume they were sustained. why does that good faith float? So anytime there's an allegation of domestic abuse, it's okay to.
No, that's actually
There's no
not.
allegation that she
that-
wasn't safe in the shelter or anything like that.
No, but she had to flee to the shelter, and she was actually,
So that gives her permission to leave the state without notifying the father?
I'm not saying that. I'm just saying.
What are you saying? Because you keep saying those.
Because it evidences that she acted in good faith. That's all I'm saying. And it's evidenced by that, not just by what she said, but by what she did. And also what she explained to her medical providers since well before any of this happened. That's all I'm saying. She had a good faith reason to do what she did. And it was also, as the court found.
Not necessarily right, but she was operating in.
Well, that's the factor, good faith. Look at the good faith belief that's the first factor under 408, or the second one. Are the parties acting in good faith or not? So. The other thing about Mr. Woyton's argument, it's statutory, and he's sort of talking about this additional requirement to sort of explain why, the why of why each factor might weigh in favor of best interests or not. And that's not in 408. And in fact, the Owen case makes the point that 408 by its terms does not require any specific findings. Instead, you get there under 25403 because in every contested, let's say, custody case, the court has to make findings as to all of the relevant factors, including the 408 factors in a relocation case.
And the reasons for which the decision is in the best interest of the child.
In 403.
Yeah.
So the implication of this is if you engraft sort of a requirement for additional analysis on this, which I don't think normally appears in minute entries or orders dealing with just, everyday legal decision-making or parenting time issues, we would have to do this in every case. Every case, not just, he suggests it's a relocation requirement. No, this, by statute, this would be a requirement in every case. And I just, again, I think that.
Well, what about Mr. Berkshire's point that relocation, particularly relocation that's a continent away, is sort of peak of the cases that should require that type of explanation because you are substantially interfering with one parent's rights.
But that's why the relocation statute says that the.
But you seem to be arguing against any sort of heightened requirement or.
Well, all I'm pointing out is that requirement, if you apply it, would logically apply to every case. Every case, you'd have to have that.
Why?
Because that's what the
Why is
statute.
relocation a completely different?
Because it's not in the relocation statute. It's in the general statute for best interest analysis. That requirement of the explanation. And yes, you would have to explain it, I guess, whatever that means. But I'm just saying, it cuts across all the cases.
The relocation statute explicitly brings in 403, right?
Yes, but it actually, in terms of findings, it works the other way around. 403 actually explicitly brings in the relocation statute. It's a bit confusing because the relocation statute starts by saying consider all the factors in 403, and then as the court found in Owen, the relocation statute doesn't require any specific findings, but 403 does. So the two statutes kind of meld together. My only point is that what he's discussing, that the statutory language, if you will, it's in 403. And that's where it says.
So I'm still not clear whether or not you're saying, as a result, there is no requirement for a Superior Court judge to explain the why of the best interest in a relocation case?
No, that's not what I think. I would say this. When Commissioner Green wrote that she didn't emphasize any particular factor, but instead, how does she put it? It's from the Pollock case. She looked at them collectively in explaining her decision. And what I'm saying is that is enough of a why to justify what she did.
It says reasons. The reasons. So one reason is enough? I mean, it says that's plural. It's got to be more than one.
She based it on all of the factors. She said, based on all these factors, I find that Ms. Ward sustained her burden of proof.
Well, that's the first requirement, to make findings on the record. That's done. Check.
Right.
And the reasons for which the decision is the best interest. You're just saying the court can just say, see above. See
Well,
above.
I think if you read that, those are the reasons, aren't they? I mean, that's the way I would read it.
Okay, but
Because otherwise,
look, break down the statute, and there's two components, clearly. Why would the legislature throw in the second? We have to presume that those words mean something, and the reasons for which the decision is in the best
All right.
interest of the child.
and all I would say, whatever.
What's the purpose?
Yeah, my point though is whatever they mean, if you heighten the requirement, you're doing that across the board with every single case involving decision-making or parenting time.
Is there a problem with that? We're talking about children here.
If you put it that way, I would say, no,
thing we could be talking about.
there's no problem doing things with children. It's just, and maybe it's, historically though, that's not what's done in general cases. Normally, the court makes the findings as to all the factors and then renders a decision. I mean, and I'm not talking about relocation cases. I'm just talking in general. That's what happens. That's what happens. One other thing I would also, I'm sorry.
I would like to talk a little bit about the current child support order, so if we could turn to that for just a brief period.
Sure.
As I understand it, there is evidence in the record of deposits into mother's account of some amount, $10,000 to $15,000, $15,000 to $20,000, that father established. That
Right.
there is these additional deposits. Why shouldn't the court have accounted for that in evaluating mother's income?
Well, it was a one-time deposit, as I understand it, and I know this is outside the record. It was actually, she deposited that money from retirement funds to pay an attorney fee in favor of father.
Did she
That's what-
establish that in the record? Because
No.
we could not find anything in the record.
No, we
that said
did
that
not.
She did.
Wouldn't it
on the
have
record,
been-
they argued about like a $2,000 deposit as evidence of sort of, a greater income. I think Commissioner Green just relied on the incomes as they stood in 2018. And my point about child support, though, is if there's an issue about that, or also any of the due process arguments he makes, the remedy would be just to remand that for correction, not send the whole case back. I want to say something about the authorities, starting with Owen and Hurd and Ramos. In every one of those, the problem was that the trial court did not make specific findings about the statutory factors either in 25-403 or 25-408. That's true without exception. In fact, Owen was a case where the trial court blocked a relocation. And this court remanded it, saying, we're looking at what you wrote, and the only thing you spilled ink on was the relationship between the child and the parent, and the father, the non-custodial parent. So from that, we can't tell whether you even considered any of the other factors, so therefore it went back. Hurd is similar. Ramos, it was a 403 factor, where the court just said, I'm not going to consider the child's adjustment to home, community, and school, because the child is only 2. And that got reversed because they say, well, community maybe not, school maybe not, but home absolutely. You can't just say, I'm not going to consider a factor. So the enduring problem is the trial court gets into trouble when it does not consider particular factors as required under the statute. And then this court will also say, well, when we look at this, we just can't tell whether you emphasized one factor too much and another factor not enough. And I would actually submit that the approach that Mr. Woyton is adopting, I think that would exacerbate that kind of a problem, because you'll always have a debate when you sort of look at the trial court's analysis of this, that, and the other thing. It seems to lead right into those sorts of disputes.
Doesn't, going back to what Judge Brown said earlier, doesn't the legislation in 403 that we talked about earlier require that? It says the reasons why. I have a hard time reading the order and figuring out which factors the court found to be compelling. I mean, we can infer that it must have been education, because that was education and grandparents, because those are the only two that kind of seem to go at all in favor of the mother. But aren't we inferring that? And doesn't our case law tell us not to make those inferences?
I would actually challenge you to find a case that actually holds that. The case law deals with situations where the trial court omitted one or more of the statutory factors, just didn't address it, didn't touch on it. That's what the case law stands for. And in this case, of course, she targeted them all. Also,
We
she...
can't infer the factors, but we can infer the reasons, is what you're suggesting.
Well, we go back to the Pollock case from 1995, which she cited. It says that you don't emphasize any particular factor, you weigh them all collectively, and that's what she did. And I would submit that is consistent with both statutes. That and requiring my client to bear the burden of proof, which she did. That's the safeguard in the relocation case, is that the parent relocating really has to demonstrate that the whole thing, that everything is in the child's best interest, that the relocation as a whole is in the child's best interest. And that is a difficult burden.
We've only got 2.5 minutes left. Turning back to Judge Perkins' question on child support, I want to make sure I understood. Are you acknowledging that there might have been an error and the court didn't account for the funds?
No. All I'm suggesting is if the court feels differently, I cited the Cook case, which was sort of a due process. It was a child support case, and there was a due process problem with respect to one aspect of it. And so all that suggests is, so what they did is they remanded that one aspect, but everything else remains. So I'm just saying that if the court disagrees, we lay out in a brief that we don't think there's an error there, but that would be the remedy if you disagree.
And so to be clear, you're saying that on this, that the record in the trial court was that mother's monthly income remained about $6,900. There was not evidence other than a single month with a single deposit?
Well, they cited maybe other deposits in their reply, but basically it's not sort of any sort of pattern. And I think I cited a case that says when you're sort of looking at that, you have to look at whether it's consistent.
There's more than one deposit?
And there might be two.
Okay.
And then also there were, and again, it's outside the record. I think she...
Yeah, let's not go outside the record. What I'm trying to get at is once father has established on the record additional sources of potential income, doesn't the burden then fall on mother to establish whether or not those were sources of income as to be accounted for?
Yeah, I think one of the cases I cited, and I didn't actually write it down in my cheat sheet, stood for the proposition that you actually have to sort of demonstrate something more than that, some sort of historical, and I happily filed something as supplement. It's cited in my brief in terms of how you look at that, even if you accept that characterization. And in my 41 seconds that are remaining, the only other thing I would say is on these due process arguments, there's a whole list of motions that they actually asked the court to adjudicate. To the extent the motions dealt with parenting time type stuff or compliance with parenting time orders, the parties presented testimony and evidence about all of that stuff. The remaining motions deal with issues about like attorney fees and other things that are extraneous. And again, we don't think there was any due process problem based on this record. But again, the remedy, again, based on the Cook case would be the same. If you think a particular motion should be reexamined, well, let's do that. Let's not throw out the whole case.
Thank you.
Thank you.
Going to bang through a couple of questions you asked. Judge Morse, page 6 of the decree, found no domestic violence. So the context statements about he did this, she did this, the actual finding from the decree was there was not domestic violence. So the history obviously would be superseded by that. The support, page 8 of our reply, goes through a chart of what the Exhibit 274 said with these monthly deposits. It was more than 1 month. I think it was, we analyzed 5, I believe, that had 30,000 this month, 17 that on the child support figure. To say that there was some other source of income. Obviously, the child care was specifically remanded last time, and there was no new evidence on the child care. One of the issues that I do think is a burden issue in this was this issue of mom's employment. One of the findings about mom didn't have a job in Yuma, but she had one in Boston. And I think that the court put a wrong burden here, and specifically the court said that neither party presented evidence about mom working in Yuma. Well, the comparison is, under the statute in 408, mom has to show the benefit of her, which would assume a starting point. Mom testified that she never even looked for a job in Yuma. And so her saying, well, I've got this great job, if somebody can just not look for a job in their home city and say, well, I'm making more in this new city, I mean, that places the burden incorrectly because they have to show the benefit. So they'd have to show, it's like a child support modification when you say, hey, I make this here and I could make this plus 5 there. But when mom didn't even look for a job, presented no evidence of what her own job is, to put that burden on the father, which is what, when you read that provision about mom's work history, that they said, well, dad didn't present it either. It's not hers. She has to show the economic benefit of going to the new city, which all she said was, I have this job here versus what I could have had in the prior city. And I do think that's, again, gets into the burden issue of otherwise, just anybody that didn't work in the first city could have a benefit by moving to the new city, which I don't think is what the legislature intended there. Unless there's any other questions. Thank you.
Thank you, counsel, for your arguments. We will take the matter under advisement and issue our decision in due course. We're going to stand in recess while we set up for the next argument. Thank you.